Eku Iluna. Please rise. Auhea o ko e ko ka aha, I nahe kuliana I mua o kia aha, ho o kolo kolo ki e hano hano o ko moku aina o Hawaii. E naoi mai, e malio mai, I lohi ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho I lalo. Please be seated.
Please call the case.
Case number SCWC-21-0000679, State of Hawaii, Respondent Plaintiff Appellee versus Charles Tung-Ming YUEN, Petitioner Defendant Appellant. Arguing for Petitioner Charles Tung-Ming YUEN, Alan M.K. Kaneshiro. Arguing for Respondent State of Hawaii, Brian R. Vincent. Argument on the merits.
All right, good morning. Aloha, everyone. The court is honored to be here today at Kailua High School as part of the Courts in the Community program. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you ready to proceed? Yes, Your Honor. All right. Court is allowed 30 minutes for each side. Just to confirm, Mr. Kaneshiro, you're going 25 minutes with your initial argument with 5 minutes reserved for rebuttal. We'll give you a warning light at 5 minutes. Mr. Vincent will give you a warning light with 5 minutes to go as well. Mr. Kaneshiro, please proceed.
Thank you. Good morning, Chief Justice Reckenwald, Associate Justices McKenna, Edens, Ginoza, and Devins. May it please the Court, Alan Kaneshiro on behalf of Defendant Appellant Petitioner Charles YUEN. First, I want to thank this Honorable Court for accepting the application for writ of certiorari in this case. It's always an honor and a privilege to appear before the court for oral argument. It's also an honor and a privilege to participate in the Courts in the Community program at Kailua High School, which is my alma mater, class of 1996. I'd also like to point out that my two associates that assisted me greatly in preparation for this oral argument, Cameron Holm, attorney, born and raised in Kailua, and Chris Phillips, a graduate of Kalaheo High School. And we really appreciate being able to present this argument to Windward Oahu community. There are two issues presented in our application for writ of certiorari. First is whether the ICA gravely erred in holding that Mr. YUEN's trial counsel was not ineffective for failing to file a motion to suppress. And second, whether the ICA gravely erred in holding that there was substantial evidence to support Mr. YUEN's conviction. And I would like to start off with the argument that trial counsel was ineffective for failing to file a motion to suppress for violation of the Posse Comitatus Act. Hereinafter, I'll refer to it as the PCA. Article 1, Section 14 of the Hawaii Constitution and the Sixth Amendment to the United States Constitution provide defendants in all criminal proceedings with the right to effective assistance of counsel at every critical stage of the prosecution. Violation of an accused's right to effective assistance of counsel warrants the irrebuttable presumption of prejudice, and a conviction will be vacated if the defendant was denied effective assistance of counsel at trial. The standard for determining the adequacy of counsel's representation is whether, when viewed as a whole, the assistance provided is within the range of competence demanded of attorneys in criminal cases. Now, first, to support an ineffective assistance of counsel claim, the defendant must show that there were specific errors or omissions reflecting counsel's lack of skill, judgment, or diligence. And in this case, we have pointed to specific errors or omissions, namely the failure of trial counsel to file a motion to suppress for violation of the PCA and a motion to suppress based on a violation of Article 1, Section 7 of the Hawaii Constitution and or the Fourth Amendment.
Well, Counsel, Mr. Kaneshiro.
Yes.
Trial counsel for your client,
Yes.
your appellate counsel for Mr. Yuen now. He did, in fact, raise issues with the trial court about excluding evidence involving the military police officers, correct?
That is correct.
And in fact, the district court judge did a pretty darn good job keeping out a lot of evidence that I think you would argue is covered by the PCA.
That is correct.
Okay.
What I would say to that point, with all respect, thank you. I guess first, this trial happened on October 8th, 2019, and a little more than 3 months prior, the Supreme Court, this court, decided State versus Chang. And State versus Chang pronounced a new rule that prospectively, hearings on motions to suppress could not be consolidated with a trial. And so while, and this rule was in effect, as I mentioned, a little over 3 months before this case went to trial. So although trial counsel in this case did raise the issue, and the court did a very good job of striking testimony and evidence sua sponte, without objection from the defense, I don't think we can construe the trial counsel's raising of the issue as a motion to suppress, because it couldn't have been consolidated into the trial. The other issue that we have is when the issue was raised by trial counsel, the prosecution sort of conceded. There was a discussion, and the prosecution conceded that we're not going to introduce anything related to the military investigation, any statements that were made to the military officers. And trial counsel seemed to be okay with that, but I think that agreement or concession by the prosecution misapprehended what the motion to suppress should have been. The motion to
Counsel, if I can ask you,
Sure.
the motion to suppress, you're trying to exclude evidence, correct?
That is correct.
Evidence that was obtained by the military officers.
That is correct.
Okay, and in this case, whether it was the attorney or the judge, sua sponte, almost none of that evidence made it into the record anyway. It wasn't part of the evidence that was considered. It certainly wasn't part of the findings that the judge used to find your client guilty. So what's the issue if it was excluded anyway?
I agree with that. The issue is the motion to suppress should have been a motion to suppress, including suppression based on the fruit of the poisonous tree doctrine. Essentially, if there was a violation of the PCA, all of the information that was obtained by military officers, which appeared to be the identity of the driver, the fact that the driver made statements that he had been drinking, there was a call to dispatch saying that they had a possible DUI at O'Malley Gate. There was apparently a field sobriety test that was administered, some sort of breathalyzer device.
No, and I understand that that evidence was excluded, but didn't the attorney seem a little unsure about his burden? Because he kept saying, it's not my burden to file the motion to suppress, and I think he may have been confused. It's an obligation. Not so much a burden as an obligation to protect your client. Do you agree or disagree with that?
I agree 100%. And he cites to, well, sorry, just getting back to my last point, all of that information that was gathered by the military was then provided to the Honolulu Police Department when they came on scene. That's how they were able to identify Mr. Yuen as the operator of the vehicle, have reasonable suspicion that he was the suspect in a crime.
Do you think the officer approaches the scene differently if he's told it's a motor vehicle accident, a civil matter versus a possible DUI? You think there's a difference in the type or mindset of the investigation?
Absolutely.
In what way?
When you're going to a scene of it's a reported criminal act, I think that the police officers are less concerned about perhaps, well, is anybody injured? What kind of property damage is there, as opposed to who is the suspect and what type of evidence am I going to try and obtain from the suspect. Getting back to your other question, Justice Devins, the trial counsel cited to State versus Torres for this proposition that the state somehow had a burden to show admissibility of the evidence. And you know, a reading of Torres, it doesn't say that at all. In Torres, the defense actually filed a motion to suppress. The motion to suppress was, the issue on appeal was whether that motion to suppress was wrongfully granted or denied. And I think that misapprehension by trial counsel of assuming or misapprehending that the state somehow had the burden to prove admissibility, I think that's just an incorrect reading of the law.
But, I'm so sorry.
Mr. Kaneshiro.
Yes.
What was the violation of the act that you're saying?
Hold on.
What was the violation of the act in your view?
So in my view, the violation of the act was military officers initiating an investigation into a civilian that was not on military property, and that their actions or their investigation did not further a military purpose.
It was 50 feet outside the gate, correct? And there are two cars that stopped there?
That is correct.
Okay, and so, by the way, it's a felony to violate the Posse Comitatus Act. So what was the felony that was committed by the military officers here?
It was taking Mr. YUEN into custody. It was administering tests to him. It was holding him or not allowing him to leave until the Honolulu Police Department arrived, and then essentially turning him over with their investigation on a silver platter.
So they should have allowed him to drive away, even including onto base, is that right?
Well, so I guess, number one, the military wouldn't have let him proceed onto the base. There is no evidence that he attempted to get onto the base. He was in the area near the gate, but Hawaii Revised Statutes 291C14, when there's a motor vehicle collision involving damage to property only, law enforcement has no obligation to investigate. It's the drivers of the vehicle have an obligation to exchange their name, their address, their registration, and present their license if requested. But there's nothing that requires law enforcement to intervene. Now, if the military officers said, okay, there's a motor vehicle collision, we see it, let's go check to see if these occupants are okay. And they go and they check to see the occupants are okay. That incidental contact that occurred because of the motor vehicle collision at some point becomes a proactive investigation into Mr. YUEN, and I think at that point it violates.
So your
the
position is they should have let him drive away?
No.
You don't think so?
No. I think it would have been absolutely fine for them to stop, even detain, even call HPD. I think it's if he had wanted to walk away, I think they should have let him walk away.
Did I just hear you say it was okay for them to stop him, detain him, and call HPD?
No, I apologize. If they had let him walk away, I think that would have been fine. If he had remained on scene and on his own volition and they had called HPD, that would have been fine. If they had said, hey, there's a motor vehicle collision, we went up to the car to see if he was okay, and I happened to smell an odor of alcohol. This is the description of the vehicle. This is his license plate. This is, where he is, what direction he's headed. He's walking away on foot. I think that would have been okay, and civilian law enforcement.
What if he had an AR-15 in the front seat?
I think that's a very different situation because
Why is it different?
Well, because the PCA seeks to, the PCA doesn't apply if there is a military purpose, and having any type of firearm 50 feet outside of a military gate has the potential to injure someone 100 feet, 200 feet within the military property.
I thought your position, reading between the lines, was that Mr. YUEN, absent the detention, the custodial stay here, could have either left or just exchanged information with the other vehicle and also left before HPD got there.
That is a possibility.
Okay, and if that was a possibility, is that part of what you were saying is, at the suppression hearing, maybe the defense would put up Mr. YUEN to testify to that effect?
That's correct.
But, but in answer to the Chief Justice's question, you said it was okay for the MPs to detain the person, but wouldn't that sort of refute the idea of, YUEN being able to dig out?
And I take that back. It was not okay for the detention to occur.
So is it the detention then, everything after that detention is the fruit that the trial attorney should have sought to preclude from evidence?
Yes.
Mr.
Well,
Kennedy,
sorry.
part of the challenge, I think, in this case is that a lot of things that you have posited as the facts are not in the record. That there was, in fact, detention, that he was taken into custody, that a field sobriety test was done, exactly why the MPs did what they did. It's 50 feet outside of the gate. They have an obligation. I take it you wouldn't disagree that to secure at least the entrance to the military base, provide safety, right? What is in the record, I think, is that the vehicle that Mr. YUEN was driving was in the left lane. Do we even know if that is a one-way entrance into the military base? I mean, those kind of facts are not in the record. Wouldn't you agree?
I would agree. And so, but I do think that the facts regarding the field sobriety test and a breathalyzer are in the record.
Okay, well, those were clearly excluded.
Correct.
Right, okay.
But they're in the record insofar as it wasn't considered by the trial judge, but the parties were aware that it occurred. Now,
Counsel, I'm going to disagree with you. Didn't the prosecutor admit, as an officer of the court, that those military officers detained your client until HPD showed up?
that is correct.
And are you arguing that everything after that was poisoned?
Correct.
Because what federal authority did they have to go off the base and detain a civilian involved in a motor vehicle collision?
None, but furthermore, it was because they came off military property onto state property and did that detention and investigation, that was the violation of the PCA.
Right, and you're not saying that they couldn't go out there at least see what happened, to check, make sure nobody was hurt, there was no danger, there was no distraction, maybe some nefarious motive to be doing something on the base. You're not saying they couldn't do that at a minimum?
Absolutely not. I'm saying that at some point the incidental contact turns into a proactive investigation.
Thank you.
And Justice Ginoza, getting back to your point, when we talk about the completeness of the record, right, we're arguing that the record has to be sufficiently complete or sufficiently developed in order for this court to determine the second prong of the ineffective assistance of counsel claim, whether it's possible that a potentially meritorious defense was impaired.
Isn't that what the ICA allowed for in its decision, though? It said its decision affirming the conviction is without prejudice to your client filing a Rule 40 petition, which is an opportunity, a proceeding to develop the record more and the facts to in fact determine whether the PCA was violated. And
I disagree with the ICA's opinion, but I'd like to, there's a fine difference, I think, that you're bringing up, and I appreciate that. There's a difference between having a sufficiently developed record for the appellate court to decide definitively on the merits whether a motion should have been suppress should have been granted or denied. In any ineffective assistance of counsel claim for failure to file a motion to suppress, the record is never going to be fully developed because that motion was not litigated at the trial court. So what has to be in the record, and when we argue a sufficiently developed record, it has to have enough facts to at least tell the appellate court that it's possible that had this motion been filed, that it would have been granted.
If the standard that you're advocating for is adopted, though, I mean, doesn't that open up almost, such a wide range of opportunity in every criminal case for this allegation by new counsel on appeal to point at trial counsel, the defendant's trial counsel, and say, you should have filed a motion to dismiss because we don't know a lot of these things, and it's possible we could have prevailed on it. Where is the line on that?
You know, I appreciate that thought, but I would respectfully disagree. With respect to violations of the PCA, really the only thing that the defense has to raise is that military officers initiated an investigation, and they have to prove that this did not occur on military property, because in State versus HAWAI, the Supreme Court makes very clear that when an alleged violation of the PCA occurs, the burden shifts to the state to show that it is not a PCA violation.
You know, you're talking about initiating investigations, but didn't you say that it's the detention itself? Is the detention combined or parallel with initiating an investigation? Aren't those two different things?
I think the initiation of the investigation is the beginning of the detention.
So it's the detention. Now let's say there was a shooting at Mokapu Gate, okay, right here in Kailua. There's a shooting, active shooting, right in that area where people maybe turn off to go into the base. Now the MP out there, she doesn't see the shooting, but she hears people screaming and yelling, and there he goes, and the person starts, digging off, and let's make it a running away, and it's a little bit shorter, different distance, let's say, into the community versus going across the pond. So she chases after him, then stops him, detains him, and then the police come. The police then do gunshot residues, so on and so forth. The guy, as he's being detained, she's saying, "Hey, where's the gun? Where's the gun? I threw it in the storm drain." For that information, they get the storm drain. Police take him in. He confesses to the offense. Is it your position that the detention by that woman MP then basically blows the whole case and everything's suppressed?
I would say that would be the case if she was actively attempting to investigate and obtain information from the suspect. Sorry.
No.
I mean, because that kind of was the case in Hawaii. The military officers did investigations of civilian drug sales,
But isn't there a difference between an investigation there, a full-on investigation, versus you got an active shooter, you have a trained military personnel who's trying to protect the community? I mean, it seems like your position would lead to some absurd results if taken to its logical extension. Tell me why not.
Well, sure. If that were to have happened and the military officer chased after the suspect, called to supervisors to inform civilian law enforcement, perhaps stopped him, detained him, tackled him, whatever the case may be, she surely wouldn't have the right to interrogate him. She surely wouldn't have the ability to...
Okay, but say he blurted out, "I threw the gun in the storm drain." I mean, does it even matter? I mean, because all the evidence is gone, right?
Right. I think that it would matter, but that's not the situation that we have in this case.
Does that person have to say also, "Well, I had a dinghy out by Kailua Bay and I was going to jump in there and nobody was going to find me," just like Mr. Yuen possibly could say, "I was going to just leave and you wouldn't find me"?
Well, I mean, that would depend on what the defense chose to present on the hearing on the motion to suppress.
Thank you.
Mr. Kaneshiro, in federal court, it's very unusual for appellate courts to consider an effective assistance of counsel claims without there being an evidentiary proceeding. And it seems to me the question we're trying to answer is the error of counsel here that you're arguing for so clear that there's just no way that a lawyer could not have looked at these facts and not filed the motion. But again, we have the vehicle 50 feet from the gate, evidence of intoxication, and if you look at the federal regulations that implement the PCA, they talk about a legitimate involvement by military personnel in search, arrest, and seizure when there's an interest of protecting DOD personnel, equipment, and official guests. It's 50 yards from the gate. He's trying to drive onto the base. Why isn't that a legitimate, at least enough to raise a question that we should have a factual hearing rather than just try to decide on the meager record we have?
Well, I would disagree that there was evidence that he was trying to drive onto the base. There's nothing in the record. He was clearly in the vicinity of the base when the gates to the base when the motor vehicle collision occurred.
Is there a turnaround there before you reach the gate?
It's not in the record.
Okay.
Is the individual who was driving Unit 2 with the 2 kids inside, do we know if they're military personnel?
It's not in the
We
record.
don't know, right?
That is correct. But those would have been all things that would have been on the state's burden to show at a hearing on a motion to suppress under HAWAI. Now,
Do you have cases that support applying the fruit of the poisonous tree to a violation of the act?
yeah, I
Under
mean-
PCA? I mean, that's pretty strong medicine usually applied for constitutional violations, and so are there cases that you think are directly applicable here?
I think HAWAI is applicable. In HAWAI, excuse me, the military officers conducted this investigation, purchased drugs from civilians, and then turned all the information over to civilian law enforcement. Civilian law enforcement then did their own undercover buys based on the military's investigation, and all of it was suppressed. Not only the evidence that was obtained by the military officers, but also the evidence that was obtained by the civilian officers, because the information came from the independent military
The
investigation.
court emphasized it was important to deter that kind of conduct, and that, as I think Justice Edens pointed out, that's a conscious decision by military authorities to become involved in an extensive series of investigations and undercover buys of civilians out in the community. Here we have a one-time incident outside the gate where the folks who are manning the gate are trying to get out there and deal with the situation that apparently, in their judgment, raised a question as to whether they had an impaired driver at their gate. Is that something we really need to deter to the level of saying that all the evidence should be suppressed?
You know, and I think that depends on how extensively this court wants to interpret the PCA. And, you know, I will concede that...
Or is it how extensive we want to interpret the exclusionary rule?
Well, the exclusionary rule, that is also part of it. The exclusionary rule has been applied to statutory violations in the past, right? I mean, State versus Scalera, State versus Edwards, State versus HAWAI. Hawaii also has a unique take on the exclusionary rule. It's not the same exclusionary rule as other exclusionary rules across the country. And again, Hawaii has a broader interpretation of what constitutes a PCA violation. And I believe that this court should consider, respectfully, the unique and delicate relationship Hawaii has with the military. Hawaii has more military personnel per capita than any other state in the country, which means that the citizens are more likely to come into contact with military, more likely, in theory, to be subject to violations of the PCA. And it's very difficult to talk about the history of Hawaii without talking about the military's involvement. I'm not saying that it's a good thing or a bad thing. It's just unique and it's delicate. You know, going back to the overthrow, 1893, the U.S. Marines assisted in overthrowing the Hawaiian government. During World War II, from 1941 to 1944, martial law was imposed, and that's the longest imposition of martial law ever in this country, since or before. Courts were run by the military, the government was run by the military, people were kicked off of their land, put into concentration camps.
No one would argue with those facts, but how do they relate to this case?
They relate to this case because they relate to how broadly this court should interpret the PCA. And every jurisdiction interprets it a little bit differently. If you go through the federal jurisdictions and state jurisdictions, different jurisdictions have different readings of what the military is permitted to do and not permitted to do. And I would respectfully request that this court take a broad view of the protections of the PCN as they relate to the people of Hawaii.
So, I'm sorry, go ahead.
Go ahead. If
So just, I want to be clear on what you think then is allowed in the context of this case, okay? So calling HPD, okay?
Okay,
Okay.
yes.
Checking out, going out beyond the gate to make sure everybody's okay?
Welfare check, okay, yes.
Okay. When HPD arrives or ambulance arrives, identifying who was driving which vehicle?
Well, in this case, there's no record of any injuries. So when you say how it applies to this case.
There were two kids in the other car, right?
Correct.
Yeah, maybe you're right. There's no record of injury, but there were minors as well as the adult in the second vehicle, which was hit, had damage to the back bumper,
It
right?
did, but, you know, and it doesn't say how bad the damage was, but the other vehicle didn't have any damage. The vehicle that allegedly hit the other vehicle in the record, according to the officers, didn't have any damage.
So very, very fact-specific in your view as to whether you can identify who was driving which vehicle.
Correct.
Whether the military police officers could identify to responding personnel, civilian personnel, whether they could tell the civilian personnel who was driving which
Correct.
vehicle.
Mr. Kaneshiro, you have a little bit of time left for rebuttal, and if need be, I'll give you a little bit more when we get there.
Thank you. I
Thank you
appreciate
very
it.
much for your
Thank you.
argument.
Good morning, Your Honors.
All right,
I'd like
Mr.
to
Vincent.
just- So sorry.
Mr. Vincent, your argument.
Thank you. I would like to just mention,
Well, you're going to have to speak up, I think.
sorry, Your Honor. I would like to just mention, just very briefly, what the purpose of this act was. This act was passed in 1878, and it was passed at the behest of the Southern Democrats. And the true purpose of this act was not to address situations like this. The true purpose of this act was to prohibit federal troops coming to the South to protect black civil rights. And that's why it makes it difficult, I think, to establish exactly what a Posse Comitatus Act violation is. The Chief Justice mentioned that this is a felony, and that's interesting. I had thought that it had never actually been charged. Nobody had ever been charged with the crime of Posse Comitatus Act, but I looked through the Congressional Researchers Service survey. It's done 2018, and it's a very thorough history. If you're interested in Civil War history, Reconstruction history, it's fascinating reading, as is the debates that surrounded the passage of this. The tension between the Southerners and the Northerners is palpable when they're discussing this topic. Okay, but let me get back. There's actually been two people charged with this Posse Comitatus Act, and their names were Captain Nicholas M. Nolan and Lieutenant Henry Ossian Flipper. And they were officers in the 10th Cavalry Regiment, which is one of the famous Buffalo Soldier regiments. Nolan was an Irishman, Irish-born officer, and his subordinate, Lieutenant Henry Ossian Flipper, was a black man who was the first graduate of the West Point Military Academy, the first black cadet who had graduated from the West Point Military Academy. And a federal marshal had come to them and asked them to seize a still, okay? And stills figure largely in the history of this Posse Comitatus Act.
Counsel, I'm sorry to interrupt, but can I ask you this? This court has held previously the purpose of the PCA is to restrict military intrusion into civilian matters.
That's correct.
Now, this case started out as a fender bender, correct?
That's correct. Mm-hmm.
But for the military getting involved running their test and detaining Mr. Yuen, would he have been free to leave the scene after he exchanged information or did whatever the Hawaii statutes require at a scene of a collision?
I would suspect that he was not free to leave.
Why not?
So because I don't think that the military guards were going to let him go. I think
Oh,
that.
but for them, would he have been free to leave after he exchanged information?
He would have been free to leave, I think, if nobody had smelled the breath, the odor of alcohol in his breath.
Right. But for the MPs getting involved, if he exchanged information, he would have been free to leave the scene before HPD showed up. Isn't that true?
He may have actually left the scene before the HPD showed up.
He would have been free to do that under his own rights.
Correct. If no one had come out and checked and
But for the MP's detention of him.
that's correct. Mm-hmm.
Thank you.
Is it your argument that because the MPs that did come out to City and County of property, which I understand there's no dispute that this was on City and County property, because they found a crime, the detention ended up being okay?
I would posit two reasons why it's not a Posse Comitatus Act. Okay. First one is that, and this appears in the original debate over the act in the Senate and probably in the House of Representatives as well, is that does a federal marshal or does a federal civilian enforcement officer, a local state civilian law enforcement officer, do they have the right to come and exercise Posse Comitatus over a citizen who just happens to be a soldier? So that's the first exception I can
So
see. To
it
Posse
is your
Comitatus.
argument, the state's argument is that a layperson that happened upon the scene could have seized the defendant?
I believe so.
Could have said, you are not free to leave.
Yes, I
And
believe
then,
so.
what if he had left then? Isn't it the color of authority, the color of being an MP that...
That's true.
Well, we actually
Right.
don't know what exactly was said because there was no motion to suppress filed.
Well,
correct?
and the officers, I think the officers were not present that day. That's. I think
I'm
the
sorry?
I think the military personnel who had originally stopped him, they weren't present in court on the day that they had
Right.
that they raised this issue.
Right.
So we don't know what they did, exactly what they did, other than the prosecutor's representations.
The defense is raising an ineffective assistance of counsel
That's correct.
claim. The first prong is lack of skill. The second is the potential impairment of a meritorious defense. And we have held that it doesn't have to be clear. It's only a possible impairment of a meritorious defense. So without a full record, we don't know whether or not there was a posse comitatus violation because posse comitatus does say it has to be a primary military purpose, right?
That's correct.
But is there anything in the record that we have right now that could indicate in any way that this was a primary military purpose?
I'm not aware of anything that would indicate that it was a primary military purpose.
If a motion to suppress had been filed, could the military MPs have been subpoenaed to testify?
I believe they were subpoenaed to testify, but they just weren't available on the day this court date.
And, of course, the court
right.
could have continued the
the
hearing
presence.
to make sure that they were
That's right.
present, right?
Mhm. Right.
And we have held in Patuai that if there is a PCA violation under the Hawaii State Constitution, the exclusionary rule does apply to exclude any fruit of the poisonous tree.
Yes, in Patuai, they did apply the exclusionary rule. Hawaii is an outlier in that respect. The federal courts don't impose an exclusionary rule.
Is this court not free to interpret its constitution
That's
to
correct.
give
It
greater
is.
rights than under the
It
federal
is, and I'm not
Constitution?
arguing Patuai was incorrect in terms of applying the exclusionary rule to this case. What I'm arguing is that this is my original argument when I filed my answering brief in the ICA was that this is per se not a Posse Comitatus Act, a violation.
And how,
for a number of reasons.
based on
For
what
two
record
reasons.
do you argue that? Because the purpose, initial purpose was the Civil War purpose?
Because I think it's very clear that this happened 50 feet from the gate of the.
What if it had been 100
base.
feet? What if it had been 100?
Yeah,
What if they heard something and they went out to the main road where someone was about to turn onto the base area?
I guess I can't. I guess there at some point.
What if it had been 50 yards?
Do they? You know, I think it's not the distance from the gate as important as whether or not this motor vehicle collision impedes access to this main gate.
Isn't this a 3-lane area? Or is that in the record?
Well, it would be shut. I don't know. I don't know if it's in the record. Yeah, I couldn't tell you that.
There is nothing in the record to indicate that traffic was impeded in any way, is there?
Well, you know, I mean, it's a distraction. It's a distraction of the ordinary ingress or egress from the. I don't know if there's egress. I don't know if there's if it comes if people come out.
In other words, the record is not developed because there was no hearing on a motion to suppress.
There was no hearing. Okay, but I would suggest that the excellent place for that hearing would be in a Rule 40 petition. So.
This court has also held that if the ineffective assistance of counsel claim is so clear, we do not need to remand for Rule 40. And does it behoove judicial economy and protection of a defendant's rights when you have different appellate counsel asserting an ineffective assistance claim and an appellate court holds, you know, there might be a ineffective assistance counsel here, but we're not going to vacate the conviction and order a motion to suppress because the defendant has a right to a Rule 40 hearing. In reality, in a Rule 40 petition, the defendant has no right to counsel, correct? Initially, when they file the Rule 40, a defendant doesn't have a right to an attorney to prepare that Rule 40 petition. So the defendant loses the benefit of appellate counsel. Isn't that true?
That's true. Mm-hmm.
Counsel, if I can ask you, the prosecutor represented to the court during the trial and said they called the HPD and detained the defendant until HPD arrived, and it was in reference to the Air Force military officers. By what authority were they acting to detain Mr. Yuen at that point in time?
Well, I would suggest that they're holding him based on their duty as a citizen to not allow crimes to happen before their face. You know.
Are you saying they weren't acting in their capacity as military police?
I think that it's. I don't think it's definitely not their primary activity to go out and check.
Okay, so by what authority, what legal authority did they have to detain Mr. Yuen at that point in time to hold him until HPD showed up?
As an ordinary citizen. As an ordinary citizen.
If I could, coming back to the Code of Federal Regulations, which says that activities, law enforcement activities, search, seizure, and arrest are permissible when it's for protection of DOD personnel, equipment, and official guests. So isn't the circumstance of an apparently DUI driver parked in a vehicle 50 feet from the gate something that could implicate that, I guess, exception to the prohibitions of the Act?
I believe so.
Are you aware of any case law that holds in that manner?
I did find one case law, and happened outside of a military base in California, and it's unpublished. I don't know if you want me to give you a citation for it.
Yes, please.
Okay. Let's see if I can find it here.
What is California law on the citability of unpublished opinions?
I don't know. I don't know. And I've been through this with Justice Acoba before, and his opinion was that out-of-state uncited opinions were citable here in the state. it didn't matter
Does it
whether
not
it was
depend?
uncitable.
Isn't it a
in the other
conflicts of
state.
laws issue? Doesn't it depend on whether or not that state allows uncitable opinions to be cited?
Yeah, it would not be citable, I guess. It would not be citable in, well, it would be citable in this jurisdiction. If it happened in this jurisdiction, it would be citable in this jurisdiction, provided it happened after 2008.
Could
and
you give us the
provided-
citation anyway?
Yeah. Let me start. It's not entirely clear exactly what happened in this case, but this is Kinney versus Easley, and the citation is 166 Federal APPX 898.
That's a
Apparently, police military officers had stopped.
Why is it an
Driver.
Apex? Was it on base?
That's a Ninth Circuit case, right? That's
It's
a Ninth Circuit case.
Yeah, it's a Ninth Circuit case. So I don't know exactly. From reading the facts of the case, it seems to be that it happened the driving happened off base. They stopped him and detained him until the police arrived.
And recognizing, of course, that we're not bound by this case law.
That's correct.
It's persuasive, if anything.
It's persuasive,
right?
if anything,
Okay.
yes.
Let me circle back to your civilian arrest point. You know, I have two kids. One is a 2015 son who graduated from Kalaheo. One is a 2022 graduate of Kailua. Let's say they are down H3. They're getting ready to go into the base on that side. My Kailua son rear ends my Kalaheo son's car. The MP sees it, comes out. My son, the Kailua son, kind of the smart alecky one, gets out. You know, he's got red, watery, glassy eyes because he's just been in Makupa body surfing. And the officer, the MP, says, "Hey, whoa, you been drinking? Not supposed to be drinking under 21. Not supposed to be even driving after having a drink if you're under 21." And he makes some flippant response to them, to the MP. The MP then calls up HPD. Meanwhile, my Kalaheo son's saying, "Hey, you know, it's okay, just damage. The only person who's going to be pissed off is Dad, who's got to pay for it, or the insurance gets skyrocketed." So he keeps the MP keeps him there until HPD comes. HPD comes, they see that there's probable cause, maybe they arrest him, charge him. What's the difference between that situation? I mean, is it okay then, under this civil idea, to detain the 2022 Kailua grad?
I think so, yes.
Okay.
It's,
And let me ask you this. I mean, I enjoyed your history lesson. It is actually quite fascinating to me. And I sort of understood from this case that passe, I never thought of, you know, Wild West kind of stuff. A
That's what
passe
usually
is,
comes
let's
to
go
mind.
out and investigate, or let's go out and find somebody. Is there a difference between that and just simply detaining somebody who you feel has committed a crime?
Yes, I think there's a difference between just detaining a person and going out and being involved in an active investigation, as you had in Paraguay.
Now, in this case, the active investigation, I guess, would have been the field sobriety test, whatever other observations. That was all suppressed in this case by not really by the efforts of the lawyer, but kind of like the courts stepped in, right? Mm-hmm. So isn't all the PCA evidence here pretty much suppressed?
It has. Yeah, it has. All the evidence has been suppressed, except for the defendant's body, who was detained. So, I'll admit.
So
I would strongly suspect he was detained.
So it seems like where both parties are talking is that the pinpoint is the detention that either kicks everything out or doesn't.
That's
Am I
correct.
there?
Yeah,
Thank
that's
you.
accurate.
In terms of determining what the actual facts were with regards surrounding if there was a detention and what the type of detention, et cetera, what is your view? And one of the challenges in this appeal is, do we vacate, based on the record we have, Mr. Yuen's conviction, and send it back to the criminal trial court, or do we, as the Intermediate Court of Appeals did, affirm the conviction, but without prejudice to him filing what you refer to and I refer to as the Rule 40 petition, right, which is a collateral proceeding where a full record could be developed. And give us your best answer as to why you believe the Rule 40 is the better proceeding.
Well, there is a third alternative. We could submit it back, we could remand it back to the trial court and have them determine the merits of this motion. And if the motion didn't have merits, and he would have his counsel with him, and if they determined that his motion did not have merits, they would just, the conviction would stand. And if it was not, and it caused him prejudice, then the case would be vacated.
And in that scenario, the concerns that Justice McKenna articulated about having counsel would be alleviated because it would still be within the criminal proceeding as opposed to the collateral Rule 40 proceeding, whether he would be entitled to appointed counsel is questionable.
Right. I mean, sometimes I wish people were appointed counsel for Rule 40s. Okay, it would be easier to deal with them. But yeah, you have a point. Yes.
Can I ask you, help us understand the best you can, what was the primary military purpose being served by these officers after they checked and made sure everybody was okay? I think there was an indication in the record that EMS and fire had already come and gone to detain Mr. YUEN. What was the primary military purpose being served at that point?
Well, I presume
50 feet off the property.
I presume that YUEN was intending to go onto the base, right?
I mean, without speculating.
So,
because that's not in the record.
Yeah. Well,
but can you articulate a primary military purpose being served at the point of detention?
One is that it would cause, a motor vehicle collision would cause congestion at the gate, the main gate of a.
Why do you have to detain him for that? Just call a tow truck, move the cars.
My guess is that it would have taken longer to get the tow truck there than it would get the police officers there.
Why do you have to detain the driver though for that?
I think that they believe that he was intoxicated. In fact, I'm pretty sure from the DPA's representations, I believe, if I'm not correct, if I'm not incorrect, is that they actually did SFSTs on him.
Right.
And I think they did it primarily to make sure that they didn't hold him any longer than they needed to. So,
well, nobody said that though.
Nobody said that. So
I appreciate it. Thank you.
Yeah.
The problem here is, as Mr. Kaneshiro said, and as you have indicated, that we don't have a record. We don't know whether he turned
that.
on and it was a wrong turn and he realized that he was approaching a military gate, and we don't know whether there was a turnaround that he could have, come back, or we don't know whether he had friends that lived nearby that he could have called to say, come pick me up while I get my car towed. I mean, we know nothing at this point, right?
Yeah, that's correct. So, anyway, is that all the questions you have?
Anything further at this time?
Okay.
Mr. Vincent?
Yeah. By the way, Lieutenant Flipper, he was acquitted. So nobody has ever been convicted of the crime of posse comitatus. No, nobody in the history. Thank you, Your Honor.
Thank you. All right. Mr. Kaneshiro, brief rebuttal. I think you had less than a minute, but I'll let you go another minute or two if you need it.
Thank you. Very, very briefly, there's some points I want to touch upon and close some doors. So Justice McKenna talked about the record being so clear that counsel was ineffective, and the case law says we have to look at the record as a whole, and there are numerous points in the record to show that counsel was ineffective. In Salavea, even though that wasn't the primary claim of ineffective assistance of counsel, the court looked at the entire record and added the fact that the defense counsel didn't object to clearly prosecutorial misconduct statements during closing arguments to bolster the idea that counsel was ineffective. Counsel allowed officers to testify without objection as to who the driver was. The counsel went down a line of questioning that only could have led to the police officers saying what the military officers told them. The last thing I want to point out is, well, two things very quickly. It couldn't have been a tactical decision not to file the motion. The defense that trial counsel ran at trial, that it wasn't City and County of Honolulu venue jurisdiction, that's been cleared up in 1991 by the ICA case State versus Thomas. Military bases, according to the Statehood Act, are part of the state of Hawaii. The City and County of Honolulu, state of Hawaii, has concurrent jurisdiction over the military bases. And so that whole defense that trial counsel attempted to raise at trial, that this was military property, therefore we shouldn't be in state court, has already been decided. And so he couldn't have chose not to file the motion to suppress, which would have required him to say that the road was state property, and then run a conflicting defense that he was arrested on military property, because a tactical decision has to benefit the defendant, and the defense that was run at trial could not have benefited the defendant.
If this had occurred on the military base, where would he have been charged, and under what law?
So he would have been probably charged in federal court, but what I would submit is whatever agreements that the state and the military police have with each other regarding, if it happens here, you take it, if it happens there, I'll take it, those are agreements. Under the Statehood Act, it is very clear that the state of Hawaii has jurisdiction, concurrent jurisdiction, over all military bases. The only military property that has exclusive jurisdiction is, there's none on Oahu. It's only when the President of the United States or the Secretary of the Defense declares that military property to be a critical area, and that's critical area is the term. And none of the bases on Oahu have been determined to be critical areas by the President or the Secretary. So HPD has full authority to enforce laws, state laws, on military bases, and that's what happened in State versus Thomas. State versus Thomas, civilian arrested on military property for abuse of a family household member, brings prosecution in state court, runs the defense. Didn't happen in the City and County of Honolulu, state of Hawaii. This court doesn't have jurisdiction over me, and it was rejected by the trial court and the ICA. Last thing, sufficiency of the evidence. Sorry. I think one important factor for the court to look at is there are no time periods. There's absolutely nothing in the record to say when this accident happened. One officer says the accident, or they arrived at 9:40. If this accident happened at 3 p.m. and the officer arrives at 9:40, in terms of sufficiency, having an officer say, I arrived and I saw Mr. YUEN in the vehicle, not in the driver's seat, not in the passenger seat, not in the rear, just in the vehicle, the timing of when the accident occurred is important, and there's nothing in the record to show that. And the ICA and the trial court relied on State versus Brown and Leona to say that circumstantial evidence can show that he's the driver, but this is a very different circumstance.
All right, Mr. Kaneshiro, thank you for your argument.
Thank you very much.
The court is going to take this matter under advisement, which means we'll issue a decision at a future time. You know, as I said at the beginning, we're so excited to be here today at Kailua High School. We're grateful to all the folks who made this happen, and I want to acknowledge some of them now. I want to begin by thanking our counsel, Alan Kaneshiro and Brian Vincent, for participating in the program here. Can you please join me in acknowledging them? And first and foremost, I want to thank the students and teachers who are here today. We have more than 300 students and teachers from Kailua High School, McKinley High School, Kalaheo High School, Lizardan Academy, and Puohala School. Please join me in acknowledging each and every one of them. We really appreciate your attention today. You're very respectful, very attentive to the arguments, and we know you put a lot of time in it because we've talked to the volunteer attorneys, and we really appreciate that you folks took this opportunity to really engage and learn what our justice system looks like when it's acting out in public and for real, because that's what this is today, a real hearing, not some mock argument. I want to thank our many distinguished guests who are here today. We're thrilled to be joined by a couple of our state representatives, Sonny Ganadin, Natalia Hussey-Burdick, and Lisa Martin, as well as Honolulu City Council Vice Chair Esther Kia Aina. Can you please join me in acknowledging our elected representatives? Our other guests include our Solicitor General from the State Attorney General's Office, Calico Fernandez, our First Deputy Attorney General, Matt Devanch. We have Board of Education member Shanti Asher is here, and we have First Deputy Public Defender Haley Cheng, and of course a whole bunch of folks from the Hawaii State Bar Association led by President Jesse Suki. So please acknowledge all of them. We are so grateful to Kailua High School for being such gracious hosts to us. As you know, we have a lot of context. I think you heard from Justice Edens. We have children who've gone to school here. Justice Ganoza at the end of the table is a proud graduate of Kailua High School. Ew, woo, surf riders. And I understand she's going to be your commencement speaker, so you got a preview today. And we want to thank everybody here at the school who made it happen. So Principal Kim Maeda, Athletic Director Ramona Takahashi, Head of Security Antone Watanabe Kuahuia, Kim Ho'olulu, Colonel Ted Pearson, and Gym Manager Mike Dubois. We really appreciate each and every one of them. Thank you. And there's some other folks behind the scenes up at the William S. Richardson School of Law. There's a student group that helped prepare the materials to help you understand the case called the Students for Public Outreach and Civic Education. I'm going to put in a pitch for that law school for those of you who might have had your interest piqued a little bit today about a career in the law. It's a wonderful law school. 3 of my colleagues, Justices McKenna, Ganoza, and Edens, are graduates of that school. And it's something you should really think about is if you're interested in a career in the law, it's a great place to go. So thanks to that group. I want to thank our volunteer attorneys. I see them scattered around the room with Leon. They're sort of the linchpin of this program. Them going out and engaging with the students to talk to them about the case is critical to this being a really meaningful experience. So please join me in acknowledging them. We have our great Supreme Court staff, Kurt Shibata, Tim Kozak, Randy Kuhau, Jan Kagehiro, Andrew Lawrence, Richard Kadagal, Tracy Clayson, Matt Matisse, Keahi Davis, our law clerks who are all here. Those are folks who work with us for a year or two after they graduate from law school. So coming back to thinking about your future, it's a great opportunity. And a special thank you to Judge Rebecca Copeland, who's helped coordinate all of the volunteers. So please join me in acknowledging them. And I mentioned the Hawaii State Bar Association. It's a great partnership with them. All these lawyers are members of HSBA. I want to thank each and every one of them who's helped. Jesse Suki, Mark Murakami, who's going to be the MC for our Q&A, Lynn Flanagan, Ryan Toyomura, and the Bar Foundation, which is their charitable arm, has covered the cost of the buses and the lunches today. So thank you to them. And one last thank you to Olelo for broadcasting this event. So with that, we're so grateful to be here. Appreciate everyone who's made this happen, and look forward to being able to engage with you in a few minutes in a Q&A. Thank you very much.
E ku iluna, please rise. Ua ho'o ku'u ia mai ne, kea aha ho'o kolo kolo ki ike hanahano o ka moku aina Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned. Please be seated.